How much money can be put in a special needs trust in Georgia? When planning for a loved one with disabilities, creating a special needs trust, SNT, is a vital step. These trusts allow families to provide financial support while preserving eligibility for government benefits such as Medicaid and Supplemental Security Income, SSI. For families in Georgia, understanding the rules around funding these trusts is essential to long-term planning and financial security. Legal guidelines for funding a special needs trust in Georgia. In Georgia, there is no state-mandated maximum contribution limit for special needs trusts. However, maintaining eligibility for federal programs like Medicaid and SSI depends on how the trust is funded and managed. For example, first-party trusts, funded with the beneficiary's own assets, must include provisions to repay Medicaid for services after the beneficiary's death. Contributions to these trusts must also occur before the beneficiary turns 65. Third-party trusts, created with assets from family members or others, do not require a payback provision. This provides greater flexibility in how they are funded. Nevertheless, funds within the trust must not be used for expenses such as housing or food, which are covered by government benefits, as this could affect eligibility. Answering the question: special needs trusts in Georgia can hold unlimited funds, but managing these funds requires adherence to strict legal and regulatory standards. Assets placed in the trust must not be disbursed in ways that conflict with the beneficiary's eligibility requirements. For example, payments should be made directly to service providers for items not covered by Medicaid or SSI, such as educational resources, specialized therapies, or recreational activities. Strategic planning and regular reviews of the trust ensure it remains compliant with changing laws and the evolving needs of the beneficiary. Defining special needs trusts: a special needs trust is a legal tool designed to manage resources for individuals with disabilities without disqualifying them from public benefits. In Georgia, these trusts are classified into three main types: first-party trusts, established with the beneficiary's assets, often from settlements or inheritances; third-party trusts, funded by others, such as parents, for the benefit of the individual; pooled trusts, managed by nonprofit organizations, combining funds from multiple beneficiaries for cost efficiency. Each type serves distinct purposes, and selecting the right one requires careful consideration of the beneficiary's needs and the source of the assets. For families looking to secure their loved one's future through a special needs trust, expert legal assistance is essential. Contact Trace Brooks Law at 1275 Peachtree Street, Nebraska No. 525, Atlanta, Georgia, 30309, or call 404-492-9559 to learn how our dedicated attorneys can help you create a tailored plan with confidence and peace of mind.